ask, you were a professor of law and economics. Why did you choose law and economics?
My training is in economics. I received a PhD from the University of Chicago, and but I grew up always interested in law. My father was a lawyer, and at the University of Chicago, where I was trained, law and economics is a specialty. It's famous for law and economics. So while I was earning my PhD in economics, I also earned a law degree, and my advisors strongly encouraged me to bring the two together. My advisor, a professor by the name of Gary Becker, a Nobel Prize winner, told me that he thought that the future of law and economics as a field of scholarship belonged to people with both a PhD in economics and a law degree, because the whole movement of law and economics began in the United States around the 60s and 1960s and 70s, and it began primarily by legal scholars without formal economics training. The most famous example is Richard Posner. But by the time I was in training, the sense was that advancement in the field required more expertise in the area of statistics, or more expertise in the area of mathematics and modeling of social systems. And so I was lucky enough, just whenever I would consider becoming just focusing on law or just on economics, Gary Becker encouraged me to bring the two together, and I think he's right. I hope he's right that
it looks as if he's right.
I hope he's right that the field is moving forward because of people who specialize in both law and economics.
So do you think that every law student should study also, have some courses in economics? Or
yeah, I think that.
So?
No, I think that's absolutely essential. I think that any legal scholar, lawyer, should have some background in economics, but also in finance and accounting, and maybe even statistics, because so much of regulation depends upon a weighing of the costs and benefits of different kinds of policies, or even interpretations of particular kinds of laws. Antitrust law is a famous example in the United States, where decisions by the Department of Justice hinge upon an analysis of markets. But outside of antitrust, you have now there's a large industry in the United States where lawyers hire economists or law and economics experts to assess damages in cases of accidents or in cases of patent disputes. And I think that a lawyer must be adept in fields like accounting, statistics, and economics to be able to understand the issues involved in the law or in the computation of damages. And I think that in the United States that it's very common now for students to get some significant exposure to cost-benefit analysis. The basic principles of economics. Is less common to get some exposure to accounting or finance, though that is increasingly common thanks to, for example, at Columbia, Zohar Goshen teaches a course on corporate finance, which is applied finance for thinking about corporations. And his class is, I think, the most popular in all of Columbia's law school.
By Zohar, you mean Professor Zohar Goshen of Ono Academic
Yes.
College, I guess,
Yes.
who's now the chairman of the Israel Security Authority.
Yes.
So why did you choose bankruptcy? Or
Well,
you specialize in bankruptcy law?
Success in academia depends upon mentors, and I was lucky enough that while at the University of Chicago, I met a professor. It was serendipity. It was just by accident. I had a conversation with a professor who specialized in bankruptcy law, and he took an interest in me, and what we say in America, he took me under his wing, and we wrote a paper together that I'd never taken a course in bankruptcy, but that interested me, and so we wrote several more papers together. I took a course in bankruptcy, and it made me realize that bankruptcy was a particular area where knowledge of economics and statistics can be very, very valuable, because I think it's one of the most interesting areas, because bankruptcy brings together so many social issues about employment, about accidents, and about failure of firms, all wound up into one. And so you have lots of social issues, you have very big economic issues about what's the best way to preserve a firm, to save jobs. And also difficult questions of finance, like what's the best way to lend to a company before it goes into bankruptcy, after. So it just seemed like a very rich area where there's so many social and moral issues, but also economic issues that makes it particularly exciting for a scholar.
So do you think that your research has practical implications? I mean, that not just a very nice paper.
Yeah, no, it's it's not
nice impressions, or that then someone can say, you say lawyers are hiring now law and economics experts. So do you have any like practical conclusions that you say, okay, my research?
Yeah, so I think that's the virtue of being someone with my training in a law school as opposed to a different kind of department, like an economics department in the United States, because in a law school you're required, but there's a very high expectation that the work you do has implications or is useful to society. And so the work I've done has been cited by courts. I've done work on financial derivatives and how courts should think about financial derivatives. I've done work thinking about how the laws should deal with the housing crisis in the United States. So I've testified before the American Congress on that. And I think that my research also has a sort of a fundamental aspect to it that I tried to think about in some of my research, how law affects behavior. That, for example, how different ways of judging can speed up a bankruptcy case, slow it down. One paper I asked was like, how would you know a good judge from a bad judge? Like, what are the characteristics of a good judge? And
judges read that as well.
Well,
they cite that as well.
Well, that paper has been cited. I don't know if it's by a judge, but it's been cited by other. I think it's been cited by judges in their non-legal writing. Okay. But it was a paper that tried to ask, like, how would you know whether a judge is? I guess it's been cited in policy debates to think about when we in the United States change our bankruptcy laws, how much discretion should we give judges? You could think of a bankruptcy system that is like a recipe for a cookbook. You do this, you do that, done. Or you could think of a bankruptcy system that says, well, we want to save the firms. Here are some minimal protections. This is the minimum protection you want to give creditors. Here's the minimum protection you must give the managers and the owners. But after that, the judges, we might give them freedom. And so that is a constant debate in the United States, that the judges have been given somewhat less discretion in recent years, and there are complaints that judges are hamstrung, that they can't exercise the discretion that's needed, that they might be forced to give creditors too much power when giving creditors too much power might mean the premature liquidation of a corporation. But my research sort of says, my research had a positive message. I looked at a particular court in Chicago and said that these judges at that time, this was back in 2001, I think it was actually 1998, it's been a while, 1998, and we looked at the discretion exercised by the judges, and along a variety of metrics, a variety of dimensions, it appeared that the judges were behaving in a way that was consistent with definitions of efficiency, and so that they were exercising their discretion in ways that preserve firms when they should be preserved, liquidated firms when they should be liquidated. So it was a positive story.
Yeah, but you said in one court.
Yeah, so when
maybe this court has very good judges and
luckily
very skilled judges.
Luckily, other scholars have replicated parts of my study in other jurisdictions and throughout. And so, for example, in 2005, the United States changed its bankruptcy laws, and Senator Russ Feingold discussed my work as evidence that we should not change the law, that at least with respect to small businesses, my study showed that judges exercise their discretion properly, and we should not enact laws that constrain that discretion. And luckily other scholars have confirmed what I found. So I think that not everything I do has direct implication, but sometimes it does. So my study of bankruptcies in 1998 was discussed by a senator in 2005, so it took some time, but
at the end, it has some implications.
And I think always in scholarship, you can't expect immediate impact. Sometimes, like Milton Friedman once said that he would never believe one study especially one empirical study. He felt that you had to wait to see a battery of an army of studies confirming the finding. Because then you can think that, okay, this is not about one court or one set of judges or one period of time. And so I think that as a scholar, you have to have that long run perspective, that not everything will have an immediate, will be an immediate hit, that it might take some time.
You said that your research results were that judges do have the right decisions, especially for small businesses. Do you think there should be different laws for small business and bigger business?
Yes, I think that one of the problems that we've seen in the United States is that small businesses are radically different than large corporations in one key respect, that the United States bankruptcy system is set up to be a fight. So you have the judge, you have senior creditors, oftentimes the banks, junior creditors, the bondholders, and then you also have equity holders and managers, and they're all fighting. And the judge is the arbiter who's supposed to decide, should I agree with the creditors and shut down the firm, or should I agree with the managers and give the firm time, or agree with the bondholders or the suppliers of trade supplies that really we need more time, we should wait and see. Or maybe they think that the firm should survive, but under different conditions. And that kind of fight plays out well in a large corporate bankruptcy because everybody has a large stake in the process. But in a small bankruptcy, typically it's a one-sided fight, or not the three-sided fight, it's only two. You have the owner of the firm, and it's usually, we're talking about a small corporation that does not have many shareholders. Maybe all the shares are held by that one owner. And then you have the bank, but you also have a lot of creditors who supplied oil or utilities, these trade creditors, these small creditors, they might supply fruits and vegetables to the restaurant, but they're not participating because their debts are not large enough relative to the cost of participating. They have to hire a lawyer, or it takes time to show up, they have to study the documents, and they're not owed enough to participate. And what we find in the United States is that judges hear from the owner, the judges hear from the bank, but they don't hear much from the what we call the unsecured creditors, the junior creditors. And so it leads to a one-sided source of information. Sometimes the bank may not be participating that much. And so the judge is not getting enough information. And so one thing we're noticing in the United States is that there are several problems. One is this lack of information. And so one thing we're entertaining is the idea of a standing trustee, that we would have a legal or business expert who could be appointed in every small business case as a neutral gatherer of information. This trustee, this expert, would sort of make sure the judge gets the full story.
And who will pay him?
Well, that would come out of recoveries to the creditors. So then you have to say, well, that sounds like a costly system. Is it better than our current system? Well, we think it would be better for a couple reasons. One is that the current system is very expensive. That it's very expensive because frequently you have cases that will last a long time and will waste value, and the judge isn't sure whether to.
Small businesses?
Even small businesses. So the statistic is that up to 25% of the value of the assets will be burned up in bankruptcy through legal fees, through just the delay of time. That a firm sitting in bankruptcy is usually not as attractive to its customers. It may not manage itself as well. It may be harder to get credit in bankruptcy. And so it's a very expensive process, partly due to the delay. And so we think that if we could a standing trustee could speed it up, give the judge information so that within 1 month, we're done. And that's a very important problem because for every 100 firms, small businesses that file for bankruptcy, only about 25 reorganize. So for every 100 that file for what we call Chapter 11, they petition the court to reorganize. So put aside, there are lots of firms that file for bankruptcy, raising the white flag, saying, that's it, we're done. But there are other firms that petition to reorganize, but for every 100 that petition to reorganize, only 25 make it through. So the judge has to decide. You know, and what my study showed that at least in Chicago and some other courts, they seem to do this pretty quickly, but it still takes time. It can take up to a year to know whether this firm is worth saving. So a trustee could help speed up that process. We also think that the trustee could help assure a more level playing field so that any reorganization process doesn't disadvantage the junior creditors, such that the bank and the owners aren't proposing a plan of reorganization that squeezes out the junior creditors. So the trustee can make sure that the recoveries are greater there. But it is a trade-off. One current trade-off that we're considering is that perhaps we should have special laws for small businesses that make it easier for them. So we also think this is a way to more easily reorganize a small business. It turns out that many small businesses actually fear bankruptcy, not because you should fear bankruptcy, but because they know it costs too much. They know they have to hire a lawyer. It's really expensive. Yeah. They have to file largely the same documents that very large corporations have to file, which is very cumbersome. So we find that many businesses will not file. They will try to use devices under what we call state law, or they will try to do anything instead of file for Chapter 11. And once they do file, it's very hard to reorganize. So we want to think of a system that makes it easier. Yeah. And we think the standing trustee could be useful for that purpose, that if a firm is viable, the standing trustee can give that information and make sure this firm is given the breathing space to reorganize. The counterweight is that, well, what if the trustee's wrong? What if he's biased? So we're now thinking about, well, maybe we need to have on the other side some protections to the creditors that what we're proposing, this new small business proposal, will largely not help banks. The banks, they're just going to probably do worse under this proposal. So we might want to say that there should be some deadlines, that if the trustee supports reorganization and the firm attempts reorganization, that if the firm fails, it should be liquidated. That's one idea, because currently under U.S. law, that you can file for Chapter 11 as many times as you want. Like if you fail once, you file again. And so one of the trade-offs we're considering is maybe making it easier for small businesses to get into Chapter 11, making it easier for them to propose a plan, giving more information to the judge, but having on the other side that having a tougher sanction, a tougher penalty if they fail. That's one of the ideas that's kind of being played around with, but it's just purely in negotiation.
Sounds really interesting and good to know that academics can help the real world and not only sit in their room and write papers for just publishing them.
Thanks.
I understand that it's your first time in Israel. How did you feel before coming to Israel?
Well, I was very excited, a little nervous, because in the United States, the most common thing you hear about Israel is the conflict with Palestine and Palestinians and the violence, and so that's one thing you worry about is whether it's as safe of a place to visit as perhaps another conference.
What did your wife think about?
She was a little nervous, but not enough to say don't go. Okay. She just thought that it's an unusual. She was a little nervous, but I think that until you visit a place, it's hard to understand the nature of any risks that you're undertaking, and I think that being here was really eye-opening.
Yeah. So how did you find Israel?
Oh, it's much. The people are much more. I didn't have any preconceived notions about how the people would be, but I was surprised at how welcoming and warm the people are in Israel, and of course, it's the history is fascinating, and to understand better the sources, the long-standing sources of conflict between nations and between ethnicities and religions. I think that living in the United States and perhaps in other countries, that you don't fully appreciate why is there tension between Jews and Arabs, or where does it come from, and it might seem to an outsider that, oh gosh, can't you just get along? Can't you just talk a little bit of talk and it'll a little bit